Family Support Services here at the ARC of San Antonio. And I want to welcome you to our webinar this morning on Special Needs Trust and the ABLE Act, which is brought to you by the ARC of San Antonio and the Mays Family Foundation. So just a few basic housekeeping items. We've muted everybody's sound and also your video just to help with our recording of this presentation. After the presentation, we'll allow time for questions. And so throughout the presentation, if you find you have a question, please just put that in the chat box. I'll monitor that, and at the end, we'll answer some of the questions from the presentation. We are recording the session, so to make it available to all families. So please do not disclose any private information, just so we can adhere to HIPAA standards. At the end of the presentation, we'll send out a link so you will be able to share this with other folks. This will also be on our website. So you can use this for future reference. So it gives me great pleasure to introduce Haley Greer. Haley is the Master Pooled Trust Director at the ARC of Texas, and she's been there since 2011. And I've had the pleasure of partnering with Haley on several presentations like this. She is an attorney and has worked at the Texas House of Representatives in the past, focusing primarily on legislation related to workforce development, health and human services, and school finance. So she will be a great resource for this information. So I'll go ahead and turn this over to Haley.
Thank you so much, Heather. It's always fun to come and present for you all. I like to get this information out to as many families as possible. So I'm glad to know that it's being recorded. Please, everyone here, share this with all of the families that you know. This is really important information that I feel like is something that people don't learn about until later. They hear a lot about and don't really know a lot. So again, my name is Haley Greer, and I am with the ARC of Texas. Been here 8.5, almost 9 years, and have learned a lot in that time. I grew up as a fan of the ARC, grew up sort of in the ARC my whole life, so I've been around pretty much my whole life. And coming into this role has been so exciting, and being able to do this and share this information and be able to provide a service to families and people with disabilities is really just such a great pleasure of mine. I will say, as I get started, there is a lot of information that I will cover in a very short amount of time. They're available or will be available, you know, for anybody to be able to access. They're available on our website as well. So if you have any questions, you know, ask them throughout, and then we'll try to answer as many as we can at the end. Again, I'm going to try to address as many as I can as I do the presentation, but please feel free to write those down, and we'll address them at the end. So what we're going to talk about today is just a quick introduction to future planning, which is sort of where this all starts. I'll talk about what a special needs trust is. I'll talk about the Master Pooled Trust, which is what I run. And then the ABLE account, which is a savings account for people with disabilities. And then at the end, we'll address your questions. So when I think about future planning, we're actually working on some new products around, or new presentations around future planning. But when I think about future planning, it's really about what are all the pieces that have to be put together for what my life, what my loved ones' lives are going to look like in the future. And one of the things, you know, here's a list of, you know, a number of the things, and definitely not all of the things, that you need to think about as you consider planning for the future. I tell families, no matter how old you are, no matter how old your child is, your grandchild, whoever, start planning as early as possible. None of this is set in stone. So just make sure that you can have some sort of planning in place, so that if anything were to happen to you or to your loved one, that you've got something in place to be able to plan for their future and your future. So, you know, we're talking things like, you know, what family's going to be around, or what friends are around. Where is the person going to live? Do you have a will? Do you have a life insurance policy, a 401k? Maybe you have a savings account. There's letters of intent, trust, able account, something, if you're not familiar with, called supported decision making, which is a fantastic alternative to guardianship. There's powers of attorney, there's actual guardianship. So there's a lot of things that you're going to think about, and those things are going to change throughout the years. So remember that these are all the things that you really want to think about. And a trust that we'll talk about today and an able account that we'll talk about today are two things that are a part of that entire plan. So they aren't in a vacuum. And so remember that all of these things sort of come together. If you're not familiar with the ARC Center for Future Planning, here is a link to it. You can also Google future planning and the ARC and it'll come up. This is the ARC of the United States. Fantastic resource to get you started in future planning. You are able to save your own plan online and really be able to change it throughout the years. You can print it. It asks you the questions and sort of gives you the prompts that you need to think about what the future is going to look like. So I recommend you check that out as well. So, like I said, a lot of information over a short amount of time. So I am going to start with the basics and sort of go from there. As Heather said, I am an attorney. I do not give legal advice, but I can sure share you some information that I have and be able to give you, some of my knowledge to be able to share, so that you're able to make great decisions. So we're going to start off talking about supplemental or special needs trust. So this is sort of the overarching idea, and then we'll get into the details from there. The first question is, what is a trust? Most people, if you're like me, like I said, I did go to law school. I did take a trust and estates class, and I'm pretty sure by the end of it, I still didn't know what a trust was. Don't worry, I know now. I'm very well aware of it now. But, trusts were those things that you always heard of that, oh, it's a trust fund baby, and, somebody who got a whole bunch of money from their grandparents and can't do what they want with it, that sort of thing. Well, that is a trust, but there's also other things that are a trust. And so what a trust really is a relationship where property is held by one party for someone else. So each trust has a beneficiary. So this is the person that the trust is set up to support. So Heather is going to set up a trust for me, and I am the beneficiary. There's also a trustee, and the trustee is the person or people or group of people that make decisions about how the money is actually spent or whatever is held in property. They make decisions about that stuff. So, so that's really what a trust is, but it's also a piece of paper. Without the piece of paper, without a written document, you do not have a trust. So I talk to families often that say, oh, I have a trust account for my daughter or my son. Unless there's a document that goes along with it, you do not have a trust. So trust is a piece of paper. It's a document that has written rules about what happens to money or property. So we think about, is that money spent or is it saved? How much of it can be spent? What can it be used for? Who can use that money? Is there property? Is there a home? Is there, a vehicle? Is there some precious jewels? What happens to those things? And it gives the rules around it. And so every trust has to have a document. So it's an actual piece of paper. When I think of a trust, so I tell people, think of a trust as a special place in which ordinary property, so money, a house, land, jewelry, anything you can pretty much think of can be placed in this trust. Once it's placed there, it takes on a new identity and it's given superpowers. So it basically becomes something that it originally wasn't. And so what that really means for a lot of folks is, so for people who have a large amount of money and they're setting aside a trust, oftentimes it's for tax purposes. So it gives it a new identity so that it's taxed differently. Well, special needs trusts are specially drafted trusts. We use them so that we can keep means tested benefits. Here's some examples of means tested benefits. And the purpose of these trusts and the superpower that they have is invisibility. So a special needs trust power is that anything that's put in a trust is now invisible for Medicaid or SSI, Social Security purposes. So what this means is that when money or property or something that is placed in trust is included in a trust, then it becomes invisible, and Medicaid and Social Security don't count it as an asset. So for those who aren't familiar or not familiar yet, to be eligible for Medicaid and Social Security, generally for Medicaid and SSI, generally you can only have $2,000 in assets. And so if you have more than $2,000, you no longer get your Medicaid services. And for a lot of people, that's a very important thing to have, is Medicaid. And so the purpose of these trusts is to make these assets that you have, the money, the home, the car, it's to make these things invisible so Social Security and Medicaid don't count them. And so this is something that, this is the whole purpose of a special needs trust, is to hold these things somewhere else so that Social Security and Medicaid don't count them and you lose your SSI or Medicaid. So why are we using a special needs trust? Number one, provide for your loved one after your passing. This is a huge piece. So when we're thinking about future planning, you're thinking about, what is my loved one's life going to look like when I'm gone? Maybe you're paying for things now that they won't be able to pay for in the future with whatever income they might have. Maybe you just want to make sure that they're taken care of, and you want to make sure that they're getting the best of the best. This is an opportunity for you to provide for them. It's also a way to manage money. I know a lot of people who, if you gave them, $150,000, $200,000, they might just squander it away. They might just pay and buy all of the things that they could ever think of, and then that money's gone. And as a family member, you want to make sure that your loved one is using that in the way that you want it to be used. And so this is a way to manage that money long term. Protects those public benefits. So that's a huge piece. Again, public benefits oftentimes say, how much do you have? This will determine whether or not we're going to give you services. And oftentimes folks are receiving SSI of right now $783 a month. And that doesn't always cover everything that you need. It rarely covers everything you need. So having a special needs trust will protect those benefits, but we'll be able to pay for extra things that help improve the quality of life. We also say that this is a safeguard for funds against predators and creditors. A lot of times what families are concerned about is that somebody is going to come and try to take advantage of their loved one. Have a story that I tell often about one of our beneficiaries who was who joined us as somebody who was older. She was in her 70s, and she met the love of her life online. He was 55. She just couldn't believe that they were in love, and they were engaged, and they were going to get married, and she was just beyond happy. And we were very happy for her. She, however, asked us to pay $30,000 as a down payment on a house. We, considered it. We wanted to find out more information. We asked her to gather all of the documents that we needed with her fiance, and we got everything together. And as we took a look at it, we realized that she was being taken advantage of. The documents that were provided were basically all fraudulent. The attorney, his office was in the Braves stadium, according to his information. His bar number was inaccurate. He wasn't actually an attorney in Georgia. And so the house wasn't owned by the people that they said the house was owned by. So we were able to protect her against that predator. She was very, very angry that we did not pay the down payment on this house. And we understood her anger. However, we knew that we had a job to protect her and make sure that she wasn't being taken advantage of. A few years later, her fiance was in Europe and needed a kidney transplant, and she wanted $10,000 for that. We also said no to that. It wasn't for her, so we couldn't pay for it. Unfortunately, you know, there are those situations that are going to happen, but when you have a special needs trust in place, those things are less likely to happen. You've got somebody who's really between those assets and those predators that are out there. It also helps against creditors. So if you have a loved one who might go and, you know, open a bank account or rather open a credit card or something and maybe get themselves into debt, the trust cannot be accessed by creditors because it's not the individual's money, it's the trust's money that is for that individual, and so creditors don't have access to it. Another big piece that we use special needs trust for is child support for individuals over the age of 18. If you are one of those people who is in this situation, please reach out to me. I'm happy to talk to you about it. But for child support for individuals over the age of 18, it's very important that you use a special needs trust or benefits could be impacted. So be sure to get in touch with me if you do have that situation. So what goes into a special needs trust? We're talking your will, your life insurance policy. You're going to use that for your financial planning. This is a way for you to say, okay, I know what I want to happen in the future, and I'm going to plan this out, and I'm going to use a special needs trust to protect assets for my loved one. It's also good for a one-time windfall of money. We get a number of folks who have SSI or SSDI back payments, so they'll get a big chunk of money that Social Security says that they're owed, and then it's like, okay, what do I got to do with this? So we do that. Lawsuit settlements, we deal here at the Master Pool Trust with a lot of lawsuit settlements. Inheritances that may or may not be appropriately planned for. So those are things that you can also do. Can also be used to hold property or mineral rights. So there's all kinds of things that can go into a special needs trust. These are just the main ones that we see. So we've talked about what a trust is, what goes into a trust. Now I'm going to get into the details about what types of special needs trusts there are out there. And there's lots and lots of things that go into a special needs trust, but the two main things when you're looking at a special needs trust is whose money is being placed in the trust. Okay, so if it is your money that you're setting aside for your loved one, it's going to be a third-party trust, okay? And this is a third party's money that is set aside on behalf of an individual with a disability. This is what you're going to use with your will, your life insurance policy. This is what we're mostly talking about today, because this is you as a parent setting aside money for your loved one. And I'll get into why this is very important that we get a third-party trust versus a self-settled trust here in a minute. So this is your money that you're setting aside for your loved one. Okay, that's a third-party trust. And then we have a self-settled trust, which is my own money that I'm setting aside for myself. So this is the beneficiary's own money that they're setting aside for themselves. It sometimes is a little confusing as to who actually owns the money, but this is if it's a person with a disability's own money, it needs to go into a self-settled trust. So these are things like money is left in a will for someone directly, that would be their own money, versus if there's money in a will that's left to a trust, that would be third-party money. So that would be a third-party trust. We're really focusing on third-party trusts here today because this is what you're talking about for your long-term plan. So the big difference between the two of these is that a third-party trust, so your money that you're setting aside for yourself, doesn't have what's called a Medicaid payback provision. So if I set up a trust for myself, I put my own money in there. So I got an SSI back payment and I'm putting it in a special needs trust for myself. What Medicaid says is that they say you can have this. You can use this money all you want. You can use every single dollar of it. But when you pass away, so when I pass away, any services that I've received from Medicaid over my lifetime have to be reimbursed to the state. So that says that we'll let you have it while while you're alive, but as soon as you've passed away, we want whatever is left in that trust up to the amount that we've paid for you. This is a federal requirement. It's going to be in all special needs trusts established with the beneficiary's own money. So any self-settled special needs trust, my own money set aside for myself, is going to have this Medicaid payback provision. This is the reason that you want to get a third-party trust set up, because if you're leaving money to one of your children and there's a good chunk left after they've passed away, you might want it to go to your other children or your grandchildren or whomever else you so choose. And so that's the big reason to make sure you get a third-party trust set up instead of things going to your child directly, and then them having to set up their own special needs trust. So this is why it's important to make sure you get those third-party monies separated from self-settled. So we also have two different things, and there's your traditional special needs trust. A traditional special needs trust is one that's established through an attorney. An attorney drafts a document. It's very specific to you and your needs, and you have to find a trustee. So a bank or an individual or a trust company can serve as trustee. One thing that I do caution folks on is making sure that you do have an appropriate trustee for your traditional special needs trust. One thing about special needs trusts is that they're not really easy to administer. So keeping up with the rules about what you can and can't pay for out of a special needs trust takes a lot of skill. And so you can have someone who is a very intelligent person, maybe they're even an attorney, but unless they do this type of work, they don't always know what the rules are. And keeping up with those rules can be daunting. So think about that as you're choosing to go with a traditional special needs trust. There are absolutely trust companies and banks that will serve, but oftentimes you also have to have a large amount of money. So some banks, I think the most that I've seen recently is about $150,000, and that's for only a handful of places will take that. A lot of them, it's over 250,000. It's $500,000 or $1 million. JP Morgan, who we work with, actually requires $10 million. So there's definitely some places that you can look, but there's also places that just aren't going to take the amount of money that you probably have set aside. I know all of us try to do well for ourselves, but even when we're gone and we've worked our whole lives, we don't always have what some other people have. So know that if you're going with a traditional special needs trust, you do have to find a trustee. And then there's pooled special needs trust, which is what I do. So a pooled special needs trust, it's established and run by a nonprofit organization. And so it's called a pooled trust because the assets can be pooled for investment purposes. And I'll get into those details here in a minute. So a traditional special needs trust, you have an individual trust document, whereas a pooled special needs trust, there's a trust document that is used by everyone in the pool. So I'll get into details now about the master pooled trust because that's what we do. So the master pooled trust is, again, it's going to be an alternative to your traditional special needs trust that you go to an attorney and have drafted for yourself. The ARC of Texas serves as the manager, so we do all the day-to-day operations of the master pooled trust. So we talk to the beneficiaries, we talk to the families, we handle distributions, we are the ones who really handle all the ins and outs of the daily activities of the trust. Providence First Trust Company is our trustee. They are just sort of the next level above us, and they also handle our taxes. So each individual account has taxes filed, so that's fun for them to do. And then JP Morgan is our financial administrator and investment advisor. So they actually distribute the checks on our behalf, distribute any distributions on our behalf, electronic or otherwise, and they also do our investments. So they're the ones who handle our investments, and it's overseen by our trust committee and our finance and operations committee. So what makes the master pooled trust master is because we have 4 master trust documents that individuals or their families can join. Right now we have, I think we actually have over 1,800 active sub accounts. But the trust's already drafted. They're ready to go. So you don't have to go to an attorney to have a trust drafted. The trust is ready to go, and all you do is join using one of our joinder agreements. So it's kind of an application that goes along with the trust documents. All 4 of our trusts help to protect benefits, and they're drafted specifically to meet Social Security and Medicaid's requirements, and they have been approved as appropriate pooled special needs trusts through Social Security. So one thing with a pooled trust or a traditional special needs trust is that if it is a self-settled trust, so it's my money that I set aside for myself, it has to be approved by Medicaid and Social Security. So if you're receiving SSI or you're receiving Medicaid, you have to provide copies of the trust document in order for them to determine if it's an appropriate special needs trust. So ours are already drafted, ready to go, and they meet Medicaid's requirements, Medicaid and Social SSI's requirements. As I mentioned earlier, pooled. So it's a master pooled trust because we pool together our assets for investment purposes. So by pooling it together, we can keep our fees to a minimum. Our minimum fee, which I'll talk about later, is $300. Whereas a lot of banks, it's somewhere around $5,000. Some have a little bit less, but most of them I would say is around $5,000. So one thing that I will note, the master pool trust is not going to be right for everybody. We can only accept cash assets. So if you have anything more than cash assets, then you're going to need to look to a traditional special needs trust or talk to us about how a traditional special needs trust and a pooled special needs trust can work together. So we do have that opportunity to work together, but we can only accept cash assets. And then each beneficiary has access to their own funds in the pool. So right now we have about $110 million. So that's the pool. And then each individual has access to only their amount of money that they have set aside. So, so we've got Jane, Jim, and Billy. And while we have $110 million, Jane only has $100,000 in her account. So Jane only has access to her $100,000. She does not have access to the entire $110 million. So each individual has their own sub account, and they have their own portion of the whole. One thing I will say is these funds are invested, as I mentioned before. And so the way that the investments work is that we actually pass those earnings back to the beneficiaries. So we have a fee that we charge every month so that we don't touch any of the investments. So the investments go right back into the beneficiary's account. Sometimes we're up, sometimes we're down. That's the reality of the market. We're up more often than we're down, but know that each individual account actually gets any earnings or losses for the month, and then we just charge our individual fee. So whose money funds a master pooled trust? So this goes back to that idea of the third party versus self-settled. So we have third party trusts. These are the ones that you're looking at today as your future plan. Okay. These are the ones that you are really thinking about. This is your long-term planning. This is what you use with your will. And our trust 1 and 3 are our third party trusts. Our trust 3 is recommended, and I'll tell you why on the next slide. Our trust 2 and 4, those are my own money that I'm setting aside for myself. So it's the beneficiary's own money. This is the one that is funded with the personal injury settlements, inheritance savings accounts. It's also where child support is going to go. So self-settled trust is for child support. Our trust 4 is recommended, and here's why. We have supplemental trusts, our trust 1 and 2. They are only for supplemental needs, no matter what. So I cannot pay for food or shelter, housing costs. I cannot pay for that with our supplemental trust. This is because we we created these trusts before all the rules, all the rules were in place. And so a few years later, we were actually able to create a second set of trusts that gave us a little bit more wiggle room. Because we already had folks who were in our trusts 1 and 2, we didn't want to make changes to those. And we wanted people to have really the option. And so we have the discretionary trust. A discretionary trust that means that it is completely up to us as to how the funds can be used. We generally are not going to pay for food or shelter unless it's appropriate for that individual. So our trust 3 and 4, which are the ones that we recommend, are discretionary, and it allows us for flexibility in the long run. As you all know, we don't know what anything's going to look like in 2 years from now, much less 10 years from now. So we want to make sure that we have the most flexibility in ensuring that your loved one is able to use the funds to have the best life that they can. So that's why we recommend our discretionary trusts 3 and 4. Again, you're going to want to think about trust 3. This is the one you're using with your will and your life insurance policy. The trust 3 is the one that we recommend. It's a third-party trust. It's discretionary. So that means that we can pay for food or shelter if we need to. And so it gives us the most flexibility to be able to protect those benefits and improve the quality of life. So again, I recommend trusts 3 and 4. The big question always is, what happens to the money after the beneficiary passes away? So if I've set aside money for myself, remember, it goes back to Medicaid first. It's outlined in our joinder agreement where the funds go if there's anything left after Medicaid is paid back. But for anybody who's been receiving Medicaid for a long time, there's often very, very high bills. The good thing though is if you plan appropriately and you use our trust 1 or 3, use trust 3, then you actually get to decide where any money goes after the person has passed away. So this is your opportunity to say, this is where I want the funds to go in the long run. Funds can be left to the master pooled trust before Medicaid is paid back or before anything is paid to any of the other beneficiaries that you might choose, but we do not have a requirement to leave anything to the trust. So there's absolutely no requirement that you leave anything to the trust. So we don't hang on to any of the money unless you want us to. The other question is how much does this cost? So your traditional special needs trust is going to cost you somewhere between $1,500 and $5,000, depending on what it is you need, what attorney you go to, what other things that they might be working on for you. So that's what's gonna cost you for a traditional special needs trust. Our fee to actually get a trust account, sub-account established is $600. So this is a one-time fee. If you are setting up a third-party trust, we will let you do $300 now and $300 when it's funded. So if you need that accommodation, please talk to us and we're happy to get that set aside. This allows you to have a trust ready to go with your will, make sure everything is good to go for you, and you know that you've got something in place right now. The good thing is you don't have to stick with us if you decide you come into win the lottery and you come into a lot of money and you're like, hey, I've got some other things I want to do. I want a traditional special needs trust. You never have to fund the one with us. So we can always be your backup, if nothing else. I like to tell everybody, make sure that we are listed somewhere as your backup in case you can't find a trustee, in case something doesn't work out. That way the funds can move over to us and we're able to administer it for your loved one if necessary. We don't have any annual fees for an unfunded account. So I have accounts that are 20 plus years old that they got set up when we first started, and they're just sitting here waiting for money to go in when the grantor passes away or when they find that it's the right time to actually fund the account. So there are no fees outside of the $600 enrollment fee. Our annual fees for when the account is funded, the minimum is $300 a year. That's $25 a month. And then it's tiered from there. So the first $50,000 is 1.75%. The next $50,000 is 1.25%, and then any amounts over $100,000 is 1%. you have a lot of money that you want to put in, come talk to me. We can also adjust this fee schedule as necessary. So we serve people with any amount of money. You can have $10,000, you can have $10 million. We will serve you. And we want to be here to make sure that everyone has the ability to have access to a special needs trust. That's why we're here. So if you have a will, or if you have a life insurance policy, or even a 401k, something along those lines, you are absolutely welcome to make the trust your beneficiary. A lot of us, I like to say, are worth more dead than we are alive, which is unfortunate. But I know that if I were to pass away, I've got more money in life insurance and my my retirement plans than I do, individually. So those are the types of things that you'll want to look at when you're funding the account. But again, we'll take any amount of money at all. So if you're interested, please, please, please reach out. I'll have my contact information at the end. But please reach out to us. That's going to finish the trust section. And now I'm going to go to the ABLE accounts. Again, hang on to your questions, and we'll try to address them as best we can at the end. So ABLE accounts. ABLE accounts are really cool. I don't know how many of you have heard about them, but they're really, really awesome. So an ABLE account is a tax-free savings account for a person with a disability. It doesn't change income rules. So if somebody gets the money directly and then puts it in the ABLE account, or even if the money is put directly into the ABLE account from working, it's not going to change income rules, but it does change those asset rules, that $2,000 that you can only have in your account. This allows you to save and still keep those benefits. ABLE stands for Achieving a Better Life Experience. It took a long time, but it finally got into law in December of 2014. Texas passed theirs in June of 2015, and then it took 3 years to be able to get it in place. But Texas does have a program now. It's been open for about 2 years, so check it out. Who can have an ABLE account? So number one thing is the onset of disability, which if we're talking to folks in this group, most likely all of you, your loved one's onset of disability was before the age of 26. So as soon as they turn 26, as long as their onset of disability, so their disability began before the age of 26, then they can have an ABLE account. The person doesn't have to be under 26 to start the account. They just had to they just had to have their disability before the age of 26. You can only have one ABLE account. No matter what, one ABLE account, wherever it is, whether it's here, whether it's somewhere else, you can only have one. An individual, a parent, a guardian, a power of attorney for an individual can establish the ABLE account. Can be funded by anyone, and a lot of states already have them open. So anyone can put money into these, and you can get it set up so that grandma and grandpa can, provide the gifts that they have, the money that maybe they give the other grandkids that they hold off giving the child with a disability. This is a way to save that money and be able to keep it long term, which is great. The cool thing about the ABLE account, y'all, there is just such great things about the ABLE account, but the ABLE account can pay for things that are qualified disability expenses. So I've got a list here. The biggest, coolest thing on this is that it can actually pay for housing and food. So most of the time, if you have benefits, if you're receiving SSI or you're receiving Medicaid and somebody else is paying for your housing or your food, then it is considered income to that individual, whatever is being paid for that. If it's paid through an ABLE account, then housing is not considered being paid for by someone else. And so it actually increases the amount of SSI an individual might receive. If you don't use it for a qualified disability expense, there is a 10% tax penalty. This is all controlled by the IRS. So this would be if you got audited or anything by the IRS, that's where you would provide any of this information. But because as long as it's used for that individual with a disability, they're generally considering it a qualified disability expense. The other great thing about an ABLE account, in my opinion, is that the person for whom the account is established is the person that is actually in control of that account. So if they're a minor, then the parent, of course, is still going to be in charge. If the individual has a guardian of the estate, then that would be who would be in charge. Or if they have a power of attorney, then that's who would be in charge. But the person with a disability actually gets to have control over this account, which is different from a special needs trust where you always have to go through a trustee to be able to make decisions. And so that's really cool. So how much can be contributed? This is the difference between an ABLE account and a special needs trust. So up to the gift tax exemption amount is what you can put in. So in 2020, it's $15,000. And the lifetime amount is whatever the amount is allowed under the 529 Educational Savings Plan. And I just got an update actually that has been increased from 370 to 4 something. I can't remember exactly what the amount is. So that has changed for Texas, but each state has their own limit. So depending on where you choose to open up your account, will determine what your limits are on the lifetime amount. No matter what, the individual per year amount is going to be the gift tax exemption, which right now is $15,000. The other cool thing is if an individual is working, they can save an additional $12,060 made from working that can be contributed to the account. So it's awesome because you can save the $15,000 and then you from anywhere, and then an extra $12,000. It's $140 in 2020. $12,140 from working. It's still income for income and for SSI and Medicaid purposes, but it's the ability to save, which is so awesome. So SSI and Medicaid benefits are protected, but as soon as you hit $100,000 in the account, the SSI cash benefit, so for some folks that's $783 a month, that is actually suspended. So you don't get the cash benefits, but you still do continue to receive Medicaid services. So that's the good piece, is that even if you're not getting the money, you are going to be able to keep that Medicaid. We're back though to the Medicaid payback. So as we talked about with a self-settled special needs trust, so my money that I'm setting aside for myself, there's also that same payback provision or similar payback provision in an ABLE account. So all ABLE accounts have this provision, but when the account holder passes away, the state has the opportunity to recover any Medicaid funds that have been spent since the inception of the ABLE. So that's a little bit different than a special needs trust. This is only going to be from the moment the ABLE account was established moving forward. So remember, there is a Medicaid payback provision. So you don't want to keep a ton of money in an ABLE account, knowing that the state could potentially get that back, and it's not used for the individual. So just be aware of that. The Texas ABLE account is open. There is tons and tons of information on their website. They have a power of attorney form. It's all done online. Almost all of the ABLE accounts are done online. So there's nowhere to go. You have to do it through an ABLE program. So you can't open it through a bank. You have to actually open it up through one of the ABLE programs throughout the country. Here's some information about the ABLE fees. So their fee is going to be $4 a month. So that's a little bit different than, the $25 a month you would have with a special needs trust. They work in tandem, but they are very different. So you definitely want to take a look at all of your options. There's more than 40 programs that are open across the country. ABLENRC.org is an awesome website that you can go and find which state and which account is right for you. Texas residents can establish accounts in Texas and several other states. There's only a handful of states where Texas residents would not be able to establish an account. So here's a quick comparison. I won't go through it, but because I want to have time for questions, but be able to take a look at that, see what that quick comparison is, and then I'm going to go ahead and go to questions now.
Oh, can you hear me?
Yes.
Oh, okay. Hold on. For some reason my video doesn't want to come on. All right, well, let's just go ahead and start with the questions. I'll work on my video. There we go.
Okay.
There we go. Okay. Can SNTs be used in all states, or do you need to redo for each state? So if you move.
Generally, they're going to be okay for most states. Each state, though, each state Medicaid program has its own rules. So it will be determined upon the state in which you move to as to whether or not it needs to be changed. Third-party special needs trusts, so the ones with your will, generally aren't going to need to be changed because they're not treated in the same way as my money that I'm setting aside for myself. So it will be determined by the Medicaid office in which you are, which the individual lives.
So this is kind of along the same lines. If a parent lives in a different state and wants to set up a trust for their child, what state would they need to set it up in?
Generally, I recommend the state in which the child lives or is planning to live, depending on what the situation is. Again, third-party special needs trusts are pretty flexible throughout it. It's just if it's my money that I'm setting aside for myself, the child's money they're setting aside for themselves, child support, those types of things. Those are going to be very state-specific, whereas third-party trusts are treated a little bit differently.
All right, can anybody change a trust? So like when a parent is no longer alive as an executor or executor is no longer available, who can change the trust?
So generally, special needs trusts are irrevocable. They can be amended. So depending, each trust document is going to have its own rules. So depending on what that trust document says will determine who or how anything can be changed within a trust. Oftentimes, there's not a lot of wiggle room to change the trust once it's been established or the grantor has passed away.
All right, can you have more than one type of trust? Can you have a self-settled and a third-party trust?
Absolutely. We actually have somebody who has 4 different accounts with us. We've tried to convince them not to have all 4, but she does have 2 third-party special needs trusts and 2 different self-settled trusts here with us. And so, yes, you can have as many trusts as you would like. You can have multiple third parties. You can have multiple first parties. You can have a pooled trust and a traditional trust. So special needs trusts are definitely more flexible in that than, say, an ABLE account where you can only have one.
Okay, and is there a maximum for the trust? One family was told they could only have up to $250,000.
No, should not be any maximum for a special needs trust. We have within our trust right now, we have several that are over, there's one that we have that's several over $2 million. Most of ours run in the $100,000 range, 100 to 150, but we have plenty that are over that. There is absolutely no reason that a special needs trust can't be over $250,000.
All right. What is the difference between the different trusts? Are there different investment strategies?
So with the ARC of Texas, at this time, we have one investment strategy for the entire pool. So all 4 trusts, the entire pool is invested in the same way. We have a conservative investment strategy. We've had about a 5%, 4.5% to 5%, depending on what month you're looking at it, annualized rate of return over the last now 20 years is what we're looking at, is about 4.5%.
Okay, and can you convert a self-settled trust to a third-party trust or vice versa?
So a self-settled trust can never be a third-party trust. The only way for a third-party trust to be a third-party trust is if a third party's money is who established it. So there's no way to go from a self-settled to a third party. Generally, if you can distribute from a third-party trust to a self-settled trust, but there's not really a reason to, and I would recommend never doing that because, again, it changes how the funds are looked at. One of the cool things that we do a lot now, though, is that we move money from either a third party or a self-settled special needs trust to an ABLE account, where funds can be used out of the ABLE account more liberally than they can in a special needs trust. So there are options on things like that, but the number one rule is a self-settled trust can never be a third party trust.
All right, is a trust of the trust 3, is that still considered invisible by other
Yes.
programs?
Absolutely. So our Trust 3 is considered invisible by SSI and Medicaid specifically. Other programs such as Section 8 housing and food stamps and other things, it should be. However, there are rules that sort of change all of the time when it comes to special needs trusts around housing. Most of the time, food stamps will exempt the asset, but it's specific to Medicaid and SSI purposes that it is 100% absolutely invisible.
All right, and so if you're in the military and you have military money, is there a recommendation of a special needs trust or an ABLE account? Is there a better account?
So depending on what the military money is. So there's, and I will say this is something that is, they just recently changed some rules around retirement benefits and individuals with disabilities and special needs trusts. So previously the money had to be left directly to the individual. Now it can be left to a special needs trust, but it does have to be a self-settled special needs trust, because the money that is going from the retirement to that individual, instead of it going to the individual, it can go to a special needs trust. It does not go to an ABLE account. As far as I know, you going to an ABLE account would not actually solve any issues as far as accessibility to services is concerned, because the ABLE account, it would still be considered income to that individual. So you'd want to go through a special needs trust. Be sure to talk to an attorney about that. You can use the master pooled trust with it. And I do have some recommendations for attorneys in San Antonio who have worked on it. So if you have that question, please reach out to me.
Okay, and someone asked, if someone leaves money after they pass in the special needs trust, can Medicaid take that money for payback? If so, how can we protect that money to go to a different person in the event of the child's passing?
So if I'm understanding the question correctly, so if funds are left in a will to a special needs trust for an individual, Medicaid cannot get that money. So that money is going to the special needs trust for that individual. Medicaid doesn't have access to those funds. And so that's the importance of the third party or the trust 3 with us, is that you want to make sure that the funds aren't left directly to the individual. Once it becomes the individual's own money, so if, say, in a will, I was leaving money to Heather, then it would be Heather's money. Even if Heather never had her on the money, it would be Heather's money. If I left the money to a special needs trust for Heather, then the funds would not be eligible to be touched by Medicaid, because they were never Heather's. That was never Heather's money. It was the trust's money for Heather. So Medicaid should not be able to access those funds. The trust document will tell you where those funds go, or the will tell you where those funds go if the beneficiary has passed away. So those rules are going to come from the will, or they're going to come from the trust document itself. So that would be something that you want to just make sure is in there correctly. So things like even life insurance policies, things like that, you want to make the beneficiary the special needs trust for the benefit of that person. So you always want to leave the money directly to the special needs trust and not to the individual directly.
Okay, and is there a place that you can check if the accounts are being managed correctly, like for an ABLE account or a trust?
When you say, so for an ABLE account, it all depends on who has access to the information. So the individual, if they are in charge of their own account, then they would need to provide information to somebody to help them oversee it or something like that. Supported decision-making agreements actually are really great, because they're able to give people access to information without making decisions. Same thing with a special needs trust. So for us, we provide quarterly statements, or we can provide, additional information to an interested party who is listed somewhere on our trust document. So we're not just going to give out information to anybody just because you want to know if it's being done right. You do have to have permission from the individual to be able to have access to that. So whether it be the individual or their representative or someone who is associated with them and their account, say with us or with the ABLE account. So I actually am a supported decision maker for a number of friends who have ABLE accounts and need help with making sure that they have access to them and they're doing everything correctly. And so I'm able to log on to their account and check out what's going on and give them the information that they need or help them make any of their transfers.
Can funds from an S&T be withdrawn and deposited into an ABLE account?
So we make distributions to ABLE accounts regularly. So absolutely, funds can be sent over to an ABLE account. You can't just withdraw, say, all of the funds, depending on how much is in there. So if it's more than $15,000, then you wouldn't be able to do that transfer or make that happen. But you can, up to $15,000, make distributions from both a third party and a first party special needs trust into an ABLE account.
Okay, we'll do one more question. If the individual is in a low-income housing, can the rent be paid from the ABLE account?
Yes, rent can be paid from an ABLE account. If they are in any type of housing, the rent can be paid from the ABLE account. I understand that HUD does recognize an ABLE account as exempt. So
awesome. Well, I want to thank Haley Greer today for her time and really great practical information for today. We encourage you to get involved by helping to protect the rights of individuals with disabilities. There are many ways to show your support, including completing the 2020 census. The Census Bureau 2020 recently announced the deadline for responding to the census. It's changed to September 30th. So it's estimated that nearly 40% of Bexar County households still have not responded to the census. So your contribution could last for 10 years. The government uses the census information to make decisions that affect people with disabilities, including public transportation, healthcare, education programs. So please consider taking a few minutes to make this huge impact by visiting my2020census.gov to help make these changes. So following this presentation, you will receive an email with a survey. So if you could fill that out, provide us feedback, we appreciate that for future presentations. The survey is going to ask for any ideas for future topics. We'll also provide a link to the recording for the webinar, and you will be able to view that in the future on the ARC's YouTube channel. Again, I want to thank the Mays Family Foundation for making the ARC's webinar series possible, and to watch our Facebook page for future webinars. I want to thank you for joining the ARC today, and we hope to see you at our next webinar. Take care and stay safe. Bye-bye.
Thank you.